Hey, good afternoon, everyone. Thanks for joining this Facebook Live that we have. Today we have a very special guest, Rachel Brenke from the LawTog. So if you haven't heard of her, she is the photographer's resource for everything legal. And we're going to talk a lot about contracts today, but specifically contracts that have to do with second shooters and assistants and people you hire, not necessarily contracts that you have with clients, although they're very important and have their own conversation at some point. But yeah, Rachel, do you want to talk about yourself, kind of tell us how you got started in weddings, or not weddings necessarily, but in photography and legal stuff?
Well, so I did do weddings for a hot bit. I was actually a photographer before I was a lawyer.
Okay.
I did photography all through law school, and that's kind of how the LawTog was born. As I was doing my photography business, I had questions, as well as people knew I was in law school, so they were asking me questions all the time. And by my third year, that the LawTog was born shortly after graduation, along with my third child. So it was kind of fun, interesting little. At first, I didn't think it was really going to go anywhere. I didn't really think it was going to become a career. And then I realized how much of a need the photography industry really has, right? You know, most of us are portrait photographers. So we're either doing individualized like family portraits or weddings, and we might cross over to some commercial work. But all the things that I teach and I talk about work for all photography industries. So from solo all the way up through big companies, but especially when it comes, like you mentioned, we're going to talk today about second shooters and any time that you're working with other people in your business. And yeah, I love it. I do. I have the LawTog, and then I also have my law firm, which I work nationally and internationally. We have a resource of a bunch of attorneys that work with us, and we do a lot of copyright infringement work because that's a huge thing we're going to touch a little bit on today. And then also contracts and other intellectual property stuff.
Yeah. So between let's talk weddings for a second here. Between a wedding photographer and somebody that they hire, what are the biggest issues that can come up that a contract would be needed for?
Yeah, so obviously, you know, most often we're talking about like second shooters or associate shooters, second shooter more commonly, right? We definitely want to have a services contract in place, much like you would have with your clients, because you want to set the expectations. You want to say like when they're going to show up, what they're going to do. You know, that's what the second shooter is giving you, the primary photographer. And what are you going to give them in return? It's probably going to be compensation or teaching or some sort of other exchange. So having a services contract in place is incredibly important. You know, it puts a little feet to the fire for you and for the second shooter, because you don't want to be twiddling your thumbs hoping that a second shooter is going to show up for the wedding and then you're without. But probably the biggest thing outside of just like the core relationship management stuff is intellectual property ownership of rights, right? The majority of second shooters are going to be 1099 contractors, right? They're independent contractors. And the word independent is to allow them to go either photograph for their own photography business. You know, a lot of people are primaries and then also do second shooting, or just for them to do second shooting for other primary wedding photographers. And with that comes that the contractors retain ownership of all of the photographs that they create in the course of the job, unless at some point they become employees, so like a W-2 status, or most importantly, like in that services contract, or having a document that's going to convey the intellectual property rights, right? The copyrights from the second shooter to the primary photographer, so that the primary can sell to the client. And it is their photography business that's on the line. So that is, outside of the services part, that intellectual property ownership piece is huge. And the reason that this is so incredibly important that a lot of primary photographers don't think about is, well, first of all, you're not the owner of the photographs that the second shooter takes, right? Unless you sign it over by contract. So what happens if the relationship goes awry and all of a sudden the second shooter is mad and revokes your license of being able to utilize the photographs, right? If the second shooter has retained ownership, they have control over distribution, reproduction, all that of those photographs. So anything that you, the primary, you know, you've sold to client, you've put into your own marketing, at that point, you could have that all revoked from you if it's not signed over.
So you're saying if there's no contract in place, if a second shooter gets paid for the job, turns the cards over, the lead shooter edits everything and is about to deliver, the second shooter can come back to them and say, can't use them.
Well, so hold on. You threw a little complication there when you said the edits, so let's put a pin in that and talk about potential
Okay.
co-authorship stuff here in a second. But yeah, I mean, really at the most granular level, and let's think of this not even just in primary, second shooter type of relationship. All businesses, all photography businesses, probably have logos that someone else has created for us. The exact same thing can happen, right? You log onto Etsy, you grab a logo, and you don't have the rights signed over. That logo creator can stop you from utilizing that logo in the future, can stop you from trademarking. So the reason I bring up that parallel is that what we're talking about here with primary and secondary shooters, this exact same idea of if you don't have ownership and you don't necessarily have a written license, you lack control and the ability to utilize and potentially could lose the ability to use those photos or logos or whatever intellectual property is, especially if it's something that you're using forward facing in your business, selling to clients, using in marketing.
Right. Okay. So you mentioned the editing side of things. So I shoot for somebody else and then somebody else edits that, the studio edits it. Is that like a co-ownership?
So let's clear up the situation we just talked about with primary and secondary shooters. We've established you need to have a contract in place that's going to convey all ownership of the photographs from second to the primary. That's the cleanest and easiest, and it's industry standard. With that, this is a little wrinkle, but the primary can license to the second shooter like permission to use those photos in their marketing, the second shooter's marketing, right? So that they have something for portfolio building, et cetera. That's common. Now, what you just mentioned was a situation where we have editors. And so let's actually take the second shooter out of the equation here for a second. Let's think about this as primary wedding photographers. If we're outsourcing to an editor, it's almost the exact same type of situation like we just had with the second shooter. Copyright has to do with the creative input of the end result of the material, so the photograph here. So primary shoots the photos, we send it off to an editor, and an editor does the edits. You run into a situation where you could have co-authorship. What that means is primary can control and reproduce and distribute and alter, but so can the editor. So this is also another example, like with an editor, you want to have a services contract that outlines this exact same thing we just talked about with second shooters, who owns what. And so like for me, everyone that photographs in my business or works in my business, I want to own it as the business owner. So same thing with your editor. You would want to have a document in place that's signing all of those artistic alterations to the photograph and manipulations to you as the primary photographer.
Yeah. Because we know that when you have a client, there's a contract, there's protections for both parties. But I've worked with many people as a second shooter. I've hired many second shooters, and it's amazing how many people do not use a contract. And they're like, oh, well, we're friends, nothing's going to happen. And it's like, well, with friends, it seems like you might even want to more so have a contract because there's more gray space. Talk into that a little bit if you have any insight.
Yeah, I just, obviously the lawyer answer is going to be have a contract all the time. And so people kind of roll their eyes. And I get that, right? Legal's not fun. But I will tell you, just as a business owner, photographer myself, I would rather on the front end set the expectations, have it all in writing. So we're not having to clean up stuff later and I have these conversations with you guys all the time. You come to the firm and you want me to help clean up a situation. I actually did have one very recently that was very costly for both parties in the almost exact same situation I just outlined. Primary photographer and editor. There was like a verbal agreement because they were friends, and then it spiraled out of control, and the relationship went awry, and it came down to not just like a breach of contract type of situation, but a copyright infringement situation. So then we're looking at even more costs. And I guess my point is, it's cheaper and easier just to put this stuff in place up front. And if you're wanting to maintain your friendships, have the writing, because then it puts you both kind of on the same playing field. You both know what the terms are. You know what the expectations are. It's easier to point to that. And I don't know what you guys, like for me, even the people that work with me don't come to me as friends. They become my friends. And so I sometimes, even as an attorney, I have difficulty of setting boundaries or saying no, right? But if I have a contract in place, I can let the contract be the no man or the backbone for me. And so I share all that in my long-winded fashion, kind of to help a perspective shift on these contracts to see all the other ways that it can help you, but especially when you're working with friends, because if you value that relationship, literally put your money where your mouth is and really value it and treat it in such a way. I know, like for me, I don't want to necessarily get into the conversation about bartering, but if you're bartering back and forth, I always say, don't barter. You can, like, this isn't illegal. This is just my kind of
Sure.
like own personal opinion. But because I don't ever with a friend want there to be any mismanaged expectations. So like for me, my own personal choice is I will pay you for your service. You pay me for my services, just like you're a regular client. And I think that's exactly the way that we should approach it as a business transaction. Use the contracts with our second shooter, our editor, and everyone. And because reality is not just protecting the primary photographer, it's protecting both parties. And that's, if it's drafted properly, lawyer drafted, it will work to do that. And it will help to create a better relationship and a better, output in the end.
Yeah. Yeah. I think that one of the other misconceptions is sometimes the person in power is the one initiating the contract. And are there scenarios where the second shooter could say, hey, lead shooter, I want you to sign this contract? I mean, is that a normal thing?
Yeah, you could do it. I mean, in this situation, with them, most status being an independent contractor, actually, you know what? Perhaps in a situation where you're an employee, you're like an associate shooter. So
Okay.
under an employee type of status, everything that the associate shooter photographs, you, the primary, and the company is going to own it. But if I'm an associate shooter who's wanting to build my own separate business, that's a conversation I have to have. And I may need to be the one as the associate shooter to come to the business and say, hey, can I utilize some of these for portfolio? Can I do some of this? Because if you just go outside of your employment status situation, you run into other issues as well as copyright infringement and things like that. And so, yeah, I do agree with you. I think oftentimes we believe that the person offering up the contract is in a power position. And that's why I kind of offer a little bit of this perspective shift. Think about it. We have contracts all the time. You download an app, you're signing a freaking contract, right? We're not reading it. We're scrolling to the bottom, but you're agreeing to terms. When you land on a website, you're agreeing to terms of site. Amazon, Walmart, Target, all of them have it. So it's not foreign concept. And I think it's how we approach it and making sure that we understand what the point in the contract is, not just because the LawTog said to have it. Like, understand why you have it, how to use it, and what's in it. And that will make everything just easier, whoever you present it to.
Yeah. Is there ever a situation where the studio has a contract that basically covers the entire relationship from job to job to job, or do you need a contract for each one?
And I think it's going to depend on status, right? Or the employee or independent
Not
contractor.
employees, just we're talking all like
Just
1099 people.
contractors.
Yeah.
You could probably do between X-term and X-term. I know, like on real estate photography side, or some people that do some sort of photography, maybe you do commercial work also outside of weddings, and you get multiple jobs that pop up, you can have in your general contract or your services contract to say, covering jobs that are confirmed by email. So you're not having to execute a contract like for realtors with real estate photographers. They're not having to execute a contract for every listing. They'll say this will cover between January and July 1, so long as you get a confirmation by email. So I don't know if that really answers your question.
No, that's helpful.
Okay.
Yeah, because there's situations where a studio hires the same second shooter for 20 weddings. And it's like, okay, do I need to have an individual contract for each of these? Or can we just say for all of 2022, these are the terms?
I wouldn't say all just because it's vague. I know the point you're getting at, like everything that you come to me, because as the primary, you're going to come to the second shooter by email or whatever. Hey, can you photograph on July 1st? And you're going to confirm, details. Yes. Okay. And so I think as long as you have language in your services contract that integrates it. And the reason I am throwing this out there is like a connector. Think of like a string. You're connecting the email to like that services contract. That's important if you ever comes into play. But especially if we're talking about here, what we talked about at the very beginning is a second shooter signing over the copyrights to the primary photographer. What if there becomes a situation where the second shooter was like, oh no, that wedding in Myrtle Beach on July 1st didn't count. And the primary is like, yes, it did, because the contract said that. We want to make sure that we can connect the dots, that every service that was done, both parties were on the same wavelength. It's funny, before we got on here, I'm writing an article called "What are the top business lessons we've learned out of the Johnny Depp Amber Heard trial?" And I was watching the clip. I don't know if you've seen it, where she confuses the terminology between donation and pledge, and Johnny Depp's lawyer calls her out for it. And Amber goes, no, they're synonymous. And I was like, bingo, because we hear that all the time, like with our clients, when they say, I want all the rights or copyrights, they don't necessarily always mean copyrights. They
right. Or retainer or deposit, things like that. Right.
Bingo, exactly. But I think the same thing when we get into relationships with, especially with our second shooters, I think, or our editors, we're like, oh, we're in the same industry. Everyone's using the same terminology. Just hop into the LawTog group. Everyone's got a different definition for everything. So it really is about like what's in your contract, how it's defined, and having that there, but connecting the dots as much as possible. So in sum of what we were just talking about, if you're going to say like all of 2022, your second shoot for me, I, as the primary, is going to have the copyrights or whatever we decide, the terms are going to be. You still want to have some sort of notice to second shooter and second shooter accepting that job, just to ensure that they're really on the hook. You don't want to just blindly send a text, never hear back, and assume that you're going to show up and you never got the text, right?
Right. Yeah, we've actually had the situation on Shoot With Me where a studio hired somebody through the platform and the person accepted the job. And per the terms of using the platform, we encourage people to have contracts, but that is the way that we define the relationship. The person accepted your job, now communicate through all the details and everything. The studio was not responding to the photographer that they hired, and the photographer reached out and they were like, hey, how do I deal with this? And we said, look, just message them off platform, try to connect however you can. And the studio was like, oh, I never confirmed. And it's like, well, yes, like the terms of use of the platform say that when you offer somebody the job and they accept it, like you're hiring them essentially. But one of the things that we're going to implement at some point is the ability for studios and for the people they hire to have contract on platform. And they'll be able to tweak it and base it off of, their situation. Studio says, hey, you can use your images, or not, or whatever, however they want to set it up, but at least the contracting will happen in platform. So it's a situation where there's a lot of nuance to it because a studio might say, hey, for these 3 jobs it's this way, and they might tweak their contract for a different job because it's
and you don't know. Let's throw in a wrinkle of a client. We're starting to see a movement of clients wanting more privacy online, right? So used to be when I would teach 5-10 years ago, and I still kind of do because I live in the DC area, like the FBI is literally 2 miles from me. So a lot of clients work for agencies like that who are unable to have online presence. That's fine, but we're seeing this wave and this push, and I think it's wonderful if clients are able to articulate to the photographer. But like you just mentioned, having a blatant contract with your second shooter that says between January 1 and December 31 of 2022, oh yeah, second, you can use all the photos from there. But what if you have a situation as the primary where you agreed to your client that you weren't going to post any photos? I mean, we have situations even outside of like career profession stuff. You might have domestic violence victims. You might have foster children that, all these things you don't know. And so I think that what I encourage with bringing that to the forefront here is consider, if you are the primary photographer, making sure that you are staying, I know this is coming from a lawyer's mouth, but stay on top of the contracts, and every time that you engage with a client, get them onboarded, look to see if there's any specifics and make sure you're providing that communication to your client. I feel like if we had that situation where we're kind of hands off, we sign once for the whole year, it gets a little too easy to kind of just let things fall through the cracks. So just keep your workflow, I guess is what I'm saying, for every single wedding, making sure you're still touching base with the second to avoid a situation like you just talked about, but also to see if there's anything you need to communicate specifically to the second shooter, whether it's privacy or otherwise.
So that kind of leads me into another question. Okay, I have a contract with somebody and everything's good, and next job I want to tweak something and I'm going to issue them a new contract. Can I go into the contract and just in plain English change up the expectations, or do I have to have that reviewed by an attorney every time?
I mean, the lawyer answer is to have it reviewed by an attorney. You can, though, like the way that we drafted the LawTog, and I'm really proud of this, actually. We have cultivated them over the years, and we have multiple states that review on a consistent basis, and there's hardly ever any changes. So legally, there's really no legal changes that need to be made. So if you are someone that you read through the contract, you understand what it says, and you've already consulted a lawyer about your workflow, your policies, procedures, any state specific stuff, you can change it up. Like, for example, maybe you're a wedding photographer and you've been requiring the remainder of the balance at least 30 days out. And then you find, oh no, I need like 60 days, to, just for administrative purposes or pursuit or whatever it is. Going in there and changing out from 30 to 60, that's not like a legally mandated thing, right? So going through when you get the contract and know what is something that's legally controlled. Like, for example, late fees are controlled by state. There is a max amount that we as service providers in contracts can put as a late fee amount that's enforceable on clients, and that's state managed. So that would be something that you would know, okay, I want to go adjust this, but I need to know what is just more like a business preference or what is a legal requirement.
Yeah. Okay, that's helpful. What about with assistance, where it's not actual like intellectual property, it's more of behavior and that type of thing?
I'm glad you asked this. Actually, so anytime you're working with anyone in your business, whether it's assistant, virtual assistant, editor, second shooter, the main documents that we want to have in place, we've already talked about services contract and like intellectual property acknowledgement, them acknowledging anything they create in the course of the business is going to be transferred to you, the primary. The other ones are like if you have an employee, you might want to look at having non-competes. Keep in mind, courts aren't a big fan of these. They love free flow commerce. So there's very specifics depending upon state. They often have to be narrowly tailored to location, length, and responsibility. So that's really more for W-2s. They're not really applicable for 1099s. The whole idea is that they're independent contractors. Right. But I will tell you, one of the other issues that we have been seeing, so the first one we talked about at the very beginning of this, issues between primary and second shooters, is the intellectual property aspect. The other big one is solicitation of the primary photographer's clients. So, and we have this in the bundle at the LawTog, the last document would be a non-solicitation. And so this is a good workaround. You can't really put a non-compete on an independent contractor, but you could put non-solicitation and confidentiality, but non-solicitation so that they're not reaching out after the wedding to your couple and trying to sell the photographs that they took or additional, you don't, or just even soliciting in general. And so having an assistant, all of these are the exact same type of documents that we suggest. And that's why we have like a general independent contractor bundle to work in all these different ways. So even if they're not creating IP for you, intellectual property, you have to consider, do they have access to proprietary information, confidential information, like payment information from your clients? Do they have access to be able to even contact your potential clients? They don't even have to necessarily be booked clients, potential, so your inquiries, but then also your existing clients as well. So non-solicitation is a good little workaround when a non-compete's not applicable.
Yeah, and I'm even more so talking like lead photographer needs to hire an assistant for lighting or whatever for a specific job.
All the things that I just mentioned.
Yeah. Okay. Yeah, that's perfect.
Yeah. It might
what
sound
about
a little overkill, but you have to consider this too. Like you mentioned, you have an assistant who, and I hear this all the time, scope creep, right? Oh, I just had him come in to do lighting, and the next thing I know, I'm having him answer emails, and he's doing this, and all of a sudden it's snowballed into this massive thing. So for me, it's just best purposes from the very beginning, having all the documents in place. So even as the classification of their status between 1099 or W-2 changes, or their responsibilities, all of it's in place.
Yeah. Can they all be boiled down into one signature thing?
I'm a big fan. There's legal practices, and this is actually, if you're listening, hopefully you guys are still listening. Sometimes breaking out your documents is best for legal purposes if they have different intentions. Just because if one gets discharged or waived inadvertently or purposely, you don't want the whole thing to be. Like, for example, on services contracts, like I just mentioned, like late fees. You want to have a late fee on there just to give a boundary and a deadline to a client. Well, you can choose to not enforce that late fee, right? We always evaluate what is our legal either obligation or what we can do, and then we kind of decide business focus, what do we want to do for our client? And just because it's in the contract saying you could charge your client $50 doesn't mean you have to. However, let's say you come to me and you're like, oh, we got really sick last week and we just can't make it to the session, or I'm not going to make my payment rather. And I go, don't worry about it another week, or don't even worry about the remainder till we shoot. We don't want that to inadvertently waive the rest of the entire contract, right? So we want to make sure we have specific language in there. but as an added step of protection, breaking out for different purposes. So like with services contracts that you have with your clients, I always recommend breaking out model release. There's many reasons for that, but really the main one I just mentioned. So back to your question here also is having your non-solicitation broken out from your services contract. Because what if your second shooter comes to you and says, hey, do you mind if I offer this to the bride and you don't mind? Well, you don't want to inadvertently waive the whole services contract that you had previously. You know what I mean? It's only the one very specific purpose that contract had that you're either enforcing or waiving.
Yeah. So let's say I'm a studio and I have been I have a normal contract with all my clients and all that's good. And I go to an attorney, local attorney, and I say, okay, I need a second shooter, independent contractor, the whole deal. I need to be protected on all of that. What are they going to charge for that typically?
Well, it depends on where you live. We did the math on it. We found for like the whole bundle that we just talked about of like with your independent contractor services, confidentiality, non-solicitation, and all that stuff, it's going to be approximately about $1,800 to $2,000. Again, that's variable. It's going to be dependent upon the credentials of the attorney. Like I really strongly suggest you don't have your friend's cousin's uncle do it who does real estate. He's not going to probably know much about intellectual property and business contracts, right? Just like any attorney can really do any sort of work. You don't want me working on your medical malpractice case because I don't even know. In my world, everything would be fixed with a Band-Aid. So,
right.
But you want to
get a specialist, right?
Yeah, a specialist that understands it, but that is going to cost more. So
if I go to you on the LawTog and I want to buy this bundle, what am I going to be paying typically?
We have it for $4.99, but we just enacted this new spinner on the site that has all these sort of discounts and fun. Plus, we have payment plans available. So you're looking at, don't do math in public, like $1,300 to $1,500 in savings by coming to us. Now, of course, the caveat always is check with your local attorney, but we've already had majority of these, evaluated by majority of states.
So when somebody purchases a contract bundle or pack or whatever from you, is it clear what they need to put in to make it unique to themselves or their situation?
Yeah, so we bold like where it says put photographer name, put your business type and all of that, and we highlight it. So when you download it and you see the yellow, that's where you need to edit something.
Let me ask you another question.
I'm scared now with the look on your face.
What prevents somebody from saying, oh, this contract looks good, I'm going to use that contract? Like, how does somebody know what is good, what is not good? And are they allowed to just take a contract that they find and say, cool, I'm going to use this?
So what I find interesting about this is how do I answer this? I think there's two ways we have to look at contracts, right? And I kind of gave a throwaway line of this earlier. We have to look at what the legal requirements are and what is legally allowed or not. Then we also want to look at what we want to do business wise, right? And so contracts are kind of a meeting of both of those. So they have to work together in that way. Plus, we have to consider very specific legal miscellany that we want to have, whether like attorney's fees, dispute resolution, waivers language, which we talked about, like inadvertently waiving the rest of the contract. Things like this is boilerplate type language. I can always tell when someone has gone to the interwebs and grabbed something or wrote it themselves. And I'm not necessarily saying you don't jot down what you want to have included. That's where I start with all my clients because we mirror our workflow. But I can always tell when you're missing this key legal miscellany stuff because you're opening yourself up for, let me give you an example. And I see this situation all the time, and I get it. I sympathize. I understand when you're first starting out, you don't have a lot of funds to invest, right? But you got to do it because I had a client, and this has happened multiple times. I've had clients come and say, hey, can you just do me a general services contract? I'm like, okay, $500, $600. Oh, no, I don't want to pay that. I'm going to go download it from the interwebs, cobble it together myself. Fast forward 9 months, their client is pursuing them and going to courts. And there's this idea that if you go to court in the US, that if you win, the loser pays your attorney's fees. there's only two ways that really happens. It's either if it's in your contract, which most DIY contracts are lacking in the proper language for it, if it's there at all, or two, some sort of statutory type of subscription for attorney's fees. But we don't have that on general breach of contract. So it has to be in the contract. So this client had come to me in like January, didn't want to pay the $500, $600 in August, September timeframe, was being sued by clients in quote unquote small claims court. And it ended up costing the client $10,000 between first suit and then appeal. Then what did he still end up having to do in the end? Pay for the $500, $600 to get the contract fixed properly to avoid it in the future, because he didn't have attorney's fees and other things that were needed that a lawyer knows to include in there. Now, I know a lot of people listen and they go, oh, that'll ever happen to me. Or no, I'll never sue a client. You just don't know. You have no idea. And especially if you're doing weddings, I feel like, you only get one shot at it. And you don't get to reschedule the day, and you don't get to retake it. Things can happen, life can happen, you just never know. And so you want to have all the protections in place up front. Absolutely.
I'm just like, as you're talking, I'm thinking back through, I've been doing weddings for 15 years, and I'm thinking back through situations where if I did not have a good contract in place, a client coming to me because I didn't get a picture of, Uncle Billy, who they never told me about. They're ticked off because I didn't get, whatever. And like, I don't want to be in a position where they're like, hey, we're going to sue you, or we're going to be in this position. Like, I know that I'm protected from that in my contract through the specific images section and whatever. But there's all kinds of situations where you're going to run into. But I think everybody pretty much understands whether or not they implement a contract with clients. I think everybody understands the importance of that. I think when it comes to the people they hire, specifically independent contractors, they think that, well, it's so rare that something's going to happen, or, there's industry standard practices, but like, you can't go into a courtroom and say industry standard practices. It doesn't really mean anything. If there's nothing spelled out.
Back from that, let's take a step back. Like, I went to the nuclear option to go into court, but you kind of were just circling around the drain on it of, we want to resolve these problems so we don't end up having to come and talk to Rachel Brenke. Like, my goal really with the LawTog and all I do in coming to this stuff is so that you guys will make a modest investment in yourselves and your business now, so you're able to resolve and like point to the contract, be on the same page, reduce ambiguities. In fact, I'll give you an example. I was trying to hire my own photographer within the last 2 months, and I get on the phone with her. It's just like a very in-person sales process. I'm like, this is great, very white glove. And I was sold, right? I was like, I'm in it. I'm good about the money. But then she starts talking about all these different products, and she's firing them off. And I've been in the industry for over 12, 15 years at this point. And so I know what products are. I've sold them. But once I got off the phone, because I didn't have any guide in front of me, I didn't really have time to ask her. I was so overwhelmed with information. I stopped and was like, and I messaged Kelly, my assistant, and I was like, what is this? What kind of product is that? I have no idea. And she's like, I don't know. And then I realized I'm in the industry. And I'm still we're having a miscommunication on definition of terms. I'm feeling lacking confidence because I don't know what something is, So think about that, especially with primary and secondary shooters. We see that a good amount of secondary shooters are newer photographers. So they're not really versed in industry standards or what things are defined. Plus, even if they're advanced, we are all defining things differently. We are all having different expectations. As a second shooter, what I do for you as a primary and for someone else as a primary could be two completely different expectations. And so, take court off the table. We want to sit and look at making sure that we're setting ourselves up for success, because the more that we put, I was about to say more we put in our contract. I don't mean more. The better well drafted a contract is and informs someone that we're working with, the less we're going to have to worry about them on wedding day, the less we're going to have potential mistakes.
Absolutely.
Yeah.
Is there anything else that you think viewers should know about contracts, specifically in regards to hiring help for their jobs or getting hired by other studios?
I mean, we've already talked the big ones. I think the big thing is if you're someone receiving one. So you're an associate photographer, you're a second photographer, and the primary is providing these documents. Don't feel like you just have to sign them. This is something, and I've been trying to think like how I might approach this on my own podcast in a couple of weeks. Like, how do we there's this idea that you get your contract done and you should be inflexible and you don't negotiate, and you don't change things. Now, the other end of the spectrum is, a client or whoever you're working with wants to negotiate everything. Right. So you have to find, as the business owner, the one that's hiring people to work with you, or even just working with clients, what am I willing to be flexible on, and understand that there may be some negotiation room. For the one that we've already talked about is maybe you're a primary photographer who is very much, I don't want seconds using any photos in their portfolio at all. If you are a second shooter, maybe consider still broaching that conversation with your primary after you've worked for them for a bit, and just develop that rapport and relationship and trust. They may be willing to renegotiate. Just, it doesn't have to be an all or nothing. And I think that's why I'm so glad that we're doing this, and why I do the LawTog is what I think. I get that legal is scary, but I'll tell you what's even more scarier is losing a business relationship, losing that client, and having to deal with legal stuff. So, equipping yourself on the front end as much as possible, because not only are you going to set up all the legal things, it's going to build confidence in yourself as a business owner. And you're going to be able to, if a second comes to you and says, oh, hey, can we negotiate on, me being able to share photos? You're not going to freak out and have to post in the LawTog. You're going to be very much, okay, what is my legal standing? Okay, what do I want to do for my business? And you can walk through it, and you'll be equipped with the information. Now, I get it. Like, you're not going to be able to understand all the legal things, and that's what I'm here for. But I think, and I even take this own process with my clients when it comes with our photography clients, is think about what are the top questions that your second shooters are bringing to you, or your associates. What are the big pain points that you're having with them, and see how can that either be prevented by contract, or do you need to supplement the contract with some sort of other knowledge base or training, etc. Because the majority of legal issues, I'll tell you, are not one major issue. It's often these little things that wear down the confidence between the two, especially when it's two industry professionals, primary and secondary shooter. It's little things throughout the process, and all of a sudden it comes to a head, and it's on the internet, and they're fighting, and then they're in the LawTog inbox. Not that that ever happens, of course, but what I'm saying is, like, most of it's preventable, right? And you guys don't want to be having to deal with me, spend the money to clean it up. You'd rather be focused on working on your photography and growing your business. And so please, 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 it sucks. I know you don't like legal stuff, but I would encourage from here, whether you're primary, secondary, think about what you want for your business. Think about the big pain points that you're having now, and how can you set yourself up to reduce them going forward, because it's going to reduce time, money, and energy you spend fixing them later on.
Right. Yeah. Yeah, and I guess the other big thing is just remembering that a contract protects both parties. It's not one-sided where the studio is domineering over the people they hire. It's also to protect them, the people that they hire, let them know when they're going to get paid, let them know when, when they're allowed to use images, if they are, and all of that specific stuff, so that if something does happen, everybody's protected, everybody's good to go. Well, very good. So in the comments below, we'll have a link to the LawTog and ways that you guys can get the contracts you guys need. Rachel, thanks for joining us today. It was great getting a deeper education on this topic.
Of course. Good to see you. Yep. You guys let me know if you need anything. Have a good one.
See ya.